Good morning, everybody. Thank you for the extended tour of Central Washington. That was really quite nice. So I'm going to start off with the slide you don't have, okay, just to change things up a little bit. Anytime you've got any questions or comments or criticism, we also get criticism. Questions or comments, just raise your hand, I'll call on you. Let's have a discussion, because I think this, what we're going to be talking about over the next 2 hours, I think is going to be critically important to you in a law enforcement legal context. So let's get everything out. There's no such thing as a room questions we're talking about in the next couple of hours here. So first slide is the slide you don't have, okay? I wanted to talk, this is based on the dinner that we had last night together, and some of the things that we talked about. I wanted to talk about what I think of as the biggest law enforcement labor challenges that exist out there right now, and I'm looking at this from a national perspective. And this is actually a short list, because there's probably 2 more slides worth of things that I could put up here, but I think these are the larger ones. The first one is we're continuing to be in the worst recruitment and retention crisis in law enforcement in our lifetimes. And it doesn't matter where you are in the country, you can't hire enough police officers, deputy sheriffs, troopers. You just can't do it. You may be in an agency where you haven't had that problem yet, but you're likely to have that problem. There are some poster children out there. I think the worst right now is the city of San Diego down in Southern California. San Diego had several years of a voter-imposed wage freeze. Actually, the voter-imposed wage freeze lasted about 6 years. The result was that officers simply fled the San Diego Police Department. They went from about 2,200 officers, and they hit their low last year somewhere around, I don't have the exact numbers, somewhere around 1,300 officers. They lost 900 officers. They couldn't hire anybody because, of course, there are suburban agencies all around San Diego, and they're not freezing their wages at the same time. They had a conservative Republican mayor who made it his personal quest to get all employees from a defined benefit retirement plan to a defined contribution plan, a 401k plan. He was the former police chief of San Diego, which made it kind of a personal betrayal, at least as far as the officers thought, and they were in a disaster. The same thing a little bit up the road in San Jose. Very much the same political pressures in San Jose coming from a mayor that resulted in caps on not only health insurance premium contributions by the employer, but also pension contributions. It got to the point where if you were a newly hired San Jose police officer, and this is only 2 years ago, over a third of your pay was going to pay for your retirement contribution and your health care contribution. Never mind taxes, Social Security, and any of that other stuff, just those 2 things. San Jose went from having 1,423 officers in 1 year to 2 years later having slightly more than 800 officers. And not because either of these cities had people who were being laid off, but instead just simply because officers were fleeing the department. It's not just those economic pressures that are at work, though. We have a different pool of potential officers today than we used to. It's a much narrower pool, right? It's a much smaller pool. And you see time and time again police agencies complaining that we just can't get people to take the entrance test. No matter who they are, we can't get them to take the entrance test. What that is doing is that is putting a downward pressure on qualifications for the job to be a police officer. And you see that all over the country right now. In my home city of Portland, Oregon, 10 years years ago, to be a police officer, you had to have a bachelor's degree. And that, from a standpoint of the workplace, is actually pretty important because there's lots of statistical studies that show that on the average, there's a positive correlation between increasing college education and performance as a police officer. So you had to have a BA to be a police officer. Today, a GED is just fine. In the New Orleans Police Department, it is no longer disqualifying for an applicant to have been convicted of a felony. What could possibly go wrong with that? And any of you in the room, when is the last time you have asked an applicant, seriously, when's the last time you used drugs? Or have you ever used drugs? Aren't you now saying, what kind of drugs were you using and how recently? It's just all of these standards that we used to have, that we used to in some cases hold inviolate, we just can't hire people. And those are going to be the standards that we have today. So that's one huge effect of this recruitment and retention problem, is the lowering of the standard. Now, the cause, beyond the economic cause, beyond the fact that we've had public sector wages that have not kept up with private sector wages, beyond the economic cause that we have a healthy labor market right now where there are opportunities, the big cause, one that everyone in this room can identify with, is people just don't want to be police officers. Nobody wants to have their life dissected and changed and fundamentally altered based on a 10-second YouTube video that is being analyzed by a nation full of video experts. Nobody wants to do that. And the people that we most want to recruit into policing today's society, women, people of color, those are the people who especially don't want to be police officers. They're the most difficult to recruit today. We've just got this major problem, and the only solution that we seem to be able to come up with right now is let's throw money at it. Right? That's at least, I think, the most effective solution so far that anybody has come up with. We have seen gargantuan wage increases in the last 2 years nationally. Wage increases we've never seen. I've been doing this, as Chris said, just about 40 years. I've never seen wage increases like this. And I've been practicing doing this in the years when we had inflation at 10 and 12% a year. We never have seen increases like this. The San Jose problem, how was that fixed? That was fixed with a 20% wage increase over 3.5 years. Sacramento, 20% over 2 years. San Diego, 30%. This is where they ended up tearing up the collective bargaining agreement and repealing the wage freeze and 30% over 3 years. Dallas, Texas, 30% over 3 years. St. Louis, 40% over 3 years. These are huge numbers, recent numbers, and they are going to, without question, expand out around the country, and they're going to have an impact. It's not all a good thing. Everybody in this room is going to get paid more as a result of it. But the fact is that municipal budgets...
That's correct.
The fact is that municipal budgets are not going to be increasing at the same rate that police wages are inevitably going to be increasing. The result is going to be that other departments and municipalities are going to be squeezed significantly. You can have pressures on raising taxes. We're looking at just a political storm that is ahead of us, and not that far ahead of us, 2-3 years down the road. Something for everybody in this room to start thinking about. And certainly the advice that we would give is start thinking about longer-term contracts. Because once these economic pressures start collapsing on you, they're going to be coming to you no matter what the effect on recruitment and retention. The last thing that we've seen with this whole issue of recruitment and retention has been what I think of as the end of police fire parity. Once upon a time, police officer wages and firefighter wages in the same jurisdiction were roughly at parity, roughly the equivalent. That is, without question, no longer the case. We used to do national wage and benefit studies. The last one we did was about 10 years ago, so that are not very current at all. But when we last looked at it 10 years ago, police officers made 8% more than firefighters in the same jurisdiction on the average, national. Today, that number must be in the double digits somewhere. Must be somewhere close to 15%. And the reason for that's easy. It's basic labor economics 101. If you post an opening for 20 firefighter jobs in whatever city you're in, how many applicants are you going to get?
2,000.
And if you open 20 police officer jobs in that same city, how many applicants are you going to get?
21, 30.
Okay.
2.5.
That's the basic labor economics, is when the supply of something is scarce, the price of it goes up. And that's what's happened to police fire parity. Put a lot of pressure on the relationship between police officers and firefighters. Nowhere do you see that more right now than in the city of Houston. In Houston, the police officers have been successful in getting a series of raises. The firefighters have not. The firefighters have put a ballot measure through the initiative process. It's going to be voted on in November that would mandate by city charter police fire parity. That will require, if the cost of that is all borne by the fire department, that will require the layoff of 600 firefighters in Houston. And they don't have that many, but 600 is a drop in the bucket. But it has also caused the police union to oppose the ballot measure, because they understand that if you're paying firefighters at a parity wage, there's less money available for police officer wage increases. And so now you have two unions that were famously good at cooperating at loggerheads. And you're going to see those tensions. It's an interesting room so far. The last thing I want to say about wages is, cities and counties, they're all under what I think of as a Me Too pressure, right? If police go out and negotiate something, they're going to have other unions that are going to say, we want whatever they got. And sometimes it's in the form of a formal clause in the collective bargaining agreement. They're called favorite nations clauses, parity clauses, Me Too clauses. Sometimes it's just political pressure that's put on the employer. And what that Me Too pressure has done has been to get police unions to start hiding money in various places in the collective bargaining agreement other than across the board wage increases. There's a gentleman in the back of the room who's wearing a Shoko t-shirt. He comes from Hawaii, comes from Honolulu. And in the Hawaii contract is the classic money hiding device that I've ever seen. And many years ago, I've helped out the Hawaii police for 12 years now. Many years ago, we decided we needed to hide some money in a wage increase. So we put 25 cents an hour in premium pay. What was the premium pay? Standard of conduct differential pay. Who got it? You got it if you were subject to the department's disciplinary rules 24 hours a day. So that means what percentage of the bargaining unit got it? Everybody got it, right? And the other unions didn't seem to notice. And so over time, we have put more and more money in it. 25 cents an hour isn't much. Today, it's $4 an hour for standard of conduct differential pay. Now we're starting to talk a fair amount of money. That's hiding money, right? Take a look at Seattle's premium structure. Seattle is almost laughable. That's a bargaining unit that has 1,100 people in it. At one time, I was negotiating the Seattle contract, and the city came to us and said, you know, there's only 28 positions in the Seattle Police Department that don't get premium pay. Only 28 positions. And we can't get anybody to take those 28 positions. Because, you know, patrol officers get 1.5%, detectives get 3%. So the city offered 1.5% premium pay for, get ready, non-premium pay assignments. And that's in the Seattle contract today. You can find it. That's hiding money. San Jose, this recent settlement that I was talking about, the 20% settlement, part of how they got there is with a new premium pay, and this is called Crisis Intervention Training Premium Pay. So if you go through Crisis Intervention Training, which is a very politically saleable notion, right? If you go through CIT training, you get an extra, at the end of this contract, it'll be 3.5%. What percentage of the bargaining unit in San Jose Police do you think is going to go through crisis intervention training? 100%. So you're starting to see more and more of this hiding money in various aspects of a collective bargaining agreement, which means that when you're negotiating your contracts, you better be reading the comparator contracts very carefully, because people are getting quite creative in how they're doing this. Look for those physical fitness incentive pays, for example, that you could pass while fully asleep. You know, those sorts of things. Okay. Next challenge that's out there, no one's talking about this very much. You may recall that we had a tax reform bill that passed in December of 2017. One of the things it did was to take a great big swipe at Obamacare. It ended the individual mandate, the obligation in Obamacare that everybody buy insurance, everybody who's employed buy insurance. It did that individual mandate, and that is now we're seeing the end of that type of insurance over the course of this year. The Congressional Budget Office, which has been pretty good about forecasting the impacts of all these different healthcare law changes that we've had, has forecast that that change alone, ending the individual mandate, will increase healthcare rates by 18% in the country. Why? Well, if you think about it, those people who are going to lose their health care due to the end of the individual mandate, and the number seems to be somewhere around 20 million people who lose their health care. Those people, does that mean they're not, when they've got a serious health condition, they're not going to get medical care? No, right? They're going to present themselves at the door of your local emergency room. Precisely the most expensive place in the country to get health care. And the emergency room, as part of the hospital, is subject to the Hill-Burton Act, which means they have to treat this individual. So are the hospitals going to simply give away that health care for free? No. What they're going to do is they're going to build the cost of providing that health care into the health insurance rates that all of us in this room are subject to. So that's where that 18% back comes. We saw the reverse of it when Obamacare passed. That's why we saw healthcare premiums flat for a couple of years when the projections had been at 18%, or excuse me, at 8% a year for each of those years. We saw the reverse of it when Obamacare came into effect. Now we're going to see the other side of it. And that is without regard to any other inflationary impact of healthcare, without regard to your utilization, without regard to the increased cost of healthcare. So just something for you to be watching out for. It's easy to predict what's going to happen with larger law enforcement agencies. They're going to look to at an even faster rate to break out from citywide groups and to buy health insurance on their own. Because law enforcement bargaining units use healthcare at a significantly lower rate than general employee unions use healthcare. The numbers vary from place to place, but it appears to be about a 22% difference in how much you use healthcare versus general employees. So as these rates go up, there's going to be more pressure on you to get out. And I think there needs to be a discussion, like the firefighters have, at the statewide level in Washington. You need to have a discussion about a law enforcement healthcare consortium where multiple agencies are able to participate. That way, smaller law enforcement groups could also benefit from this notion that you have a lower utilization rate. Okay, questions on, I've gone over a lot very quickly. Questions on any of that or comments, thoughts? Okay. Well, maybe in the morning. The third thing that's going on, the public wants to get into police collective bargaining now. They want to get into the bargaining process. You see pushes for opening negotiations under public meetings laws so that you can have representatives of the public there at those meetings. You are seeing in various places around the country post-settlement but pre-ratification protests of collective bargaining agreements. So major deal with who's ever on the other side of the table, it gets presented to the city council, and all of a sudden the protesters show up. Everybody here know what Campaign Zero is? Everybody? Okay. This is in Campaign Zero's playbook. It's in their online playbook. You can actually go and see. It is their intent to do this in every city in the country eventually. And it has worked in some places. There was a really non-controversial settlement agreement reached last year between the Austin, Texas Police Department and the POA there, and it got completely derailed at the city council ratification process because of public protests about not enough, their phrase was police accountability, whatever it meant in that particular context. You've seen that locally in Seattle from time to time, where the public wants to get involved in the collective bargaining process. We had it down in Portland about 5 years ago, and the city council told us we actually won't sit down in bargaining with you unless the public is allowed in. And so we thought about that. We had a basis to oppose that under the public meetings law, but then we'd look horrible, right, if we want to oppose that under the public meetings law. So we reached another solution, which was we'd have all the discussions we wanted to at the table with the 5 members of the public sitting right there, the same 5 members of the public, and then we'd go have coffee. And when we had coffee, that's where the real discussions happen, and that's where the settlement of the contract happens. You see this all over the place. I was a witness in the interest arbitration over San Francisco police officer wages this year. They had public protesters holding signs as you walked in the door for the interest arbitration hearing. This is, again, this is just starting, but this is something you have to be aware of. Obviously, the bigger the city, the closer you are to Tacoma, the more likelihood you're going to face this sort of thing. But any city anywhere can face it, depending upon whether you've had a high-profile incident or whatever it might be. We are also seeing 940, a good example, state legislatures focusing on amendments to police-related laws. Of course, I-940 taking a shot at a wide variety of police issues, everything from training to deadly force standards to the obligation of, well, you know the content of I-940. We've seen the same thing this year in California. The last 2 bills that the California legislature considered this year, passed one, didn't pass the other. They were both police bills. The one that they did pass opened up body camera video to public viewing. The one that they did not pass is their equivalent of I-940 that actually would have been much worse than I-940. It would have moved to what I think of as Graham versus Connor light. So having the Graham versus Connor standard, the reasonable police officer standard used to adjudge deadly force situations. But in addition to Graham versus Connor, you would also consider in hindsight whether the officer had alternatives to the use of deadly force. That's a bill that didn't make it out of the California legislature, but the proponents of the bill have said, we will be back, and they will be back in 4 months when the legislature is back in session. You're seeing this stuff all over the country, not just on the West Coast. You're seeing this in Arizona, you're seeing it in a wide variety of different places. These are sort of end runs around the collective bargaining process, end runs around court decisions, Graham versus Connor, that you're seeing at the legislative level, which of course makes it all the more important for police unions in this country to be politically active. And Chris has heard me say this before, many of you in the room have. I'm sorry for repeating it, but for those of you who haven't heard it, when I started practicing, I'm a lawyer by trade. I came into this thinking that lawyers were the best thing for police union negotiations. They were the single most important tool that a police union could have in its arsenal. It's been my mission over time to try to professionalize the whole process of labor relations. Try to get the analysis of wages and benefits onto a quantitative basis where you could make persuasive arguments based on the data and things like that. I'll admit that I'm looking up now and I'm thinking the most important person that you need is some sort of public relations consultant. Somebody who is a pro at understanding what life is like out there right now and how you can deal with it. Because that's where the biggest political pressures or the biggest pressures on the bargaining process are coming, is from the political system right now. They're not coming at the bargaining table. Because of the effect of the recruitment and retention crisis, you have employers willing to give you wages now. Well, we don't have hard-fought battles over wages. You look at Washington, I don't know if you know this, but if you look at PERC's website, they have every interest arbitration decision listed there for many, many years. And we're at the rate now, in terms of police interest arbitrations, of like 2 or 3 a year. We're not having battles over wages anymore. We're not having battles over benefits. Those are being settled at the table. The pressures are coming through the political system. Okay. Next up, it has become painfully aware. By the way, fair warning, I'm likely to offend some of you in the room with this discussion. Okay? It has become painfully aware that we do not have an effective national voice for police unions. There are only 3 national organizations that are out there that are of any size. The largest, probably, who knows, the claims vary and they're subject to questioning. Largest, probably the FOP. The second largest, probably NAPO. Third largest, IUBA. And none of them, in my judgment, is worth anything in terms of a national voice for police unions. A national voice that is remotely comparable to the national voice of the International Association of Firefighters. I would ask all of you in the room a simple question. Name me one piece of federal legislation that has been passed in the last 20 years that meaningfully impacts the law enforcement workplace. Just one.
Right to carry.
Hmm?
The national right to carry.
Oh, give me a break. That is, the little treat that you give your dog every once in a while to keep them happy. I'm talking about something that improves your work life. Right now, maybe the cops grants, maybe. I don't know. That's as close as I can get. Why is that the case? I can give you half a dozen on the firefighter side related to safety standards and different things like that. We just don't have an effective national voice. And somehow or another, those of you who are affiliated with these national organizations have to begin the process, and it's going to be a process. It is going to be a years-long process. You have to begin the process of consolidating and changing these organizations. The FOP needs to be something more than a retiree organization, a retiree-driven organization. NAPO needs to be something other than an organization that exists to preserve the jobs of the staff. These organizations need to be working for you effectively. They need younger voices. We were talking at dinner last night. The leaders of these three organizations have an average age that is probably around 70 years old. You know, the head of the FOP is a retired police lieutenant from Charleston, South Carolina. Collective bargaining is illegal in South Carolina. No collective. Why is this the case? Why don't we have a national union? It has got to come from the ground up. It cannot come from these organizations that are in Washington, D.C. and, Sarasota, Florida. Yeah, I've given a hard time about that quite frequently. So, at any rate, this is, I think, becoming very, very important. You're also now clearly in the most bizarre political vice spelled vice wrong there. Yeah, I think I spelled vice wrong. I used the wrong vice. Sorry about that. You have pressure from both the left and the right now. Law enforcement does. And it's oddly pressure in the same area. You know, there's always been pressure on the left with respect to reform of police practices. I mean, we've always seen that, right, throughout all of our careers. We've always seen pressure from the right on your wages and benefits and your pensions. They don't like any of that. They would rather you be paid as least as you can, and they want defined contribution pension plans. We've always seen that. What we are oddly seeing right now is the two sides, particularly when you get out to the extremes. When you get to, on one hand, the Project Zero people, and on the other hand, the Koch brothers, we're seeing them speaking the same language and agreeing with respect to what they talk about as police reforms. Did you know that some of the biggest pressure right now on Graham versus Connor is coming out of Koch brothers supported organizations? I assume you all know what the Heritage Foundation is. Heritage Foundation is a very important nonprofit, largely funded by the Koch brothers. Do you know they're the sponsor of a webpage called policemisconduct.net, where they collect incidents of what they refer to as police misconduct and advocate getting rid of statewide peace officer Bill of Rights and things like that. You're in this odd spot right now where you have the political extremes uniting over police practices. That puts you in a difficult position. I'm assuming you're going to see that. I'm looking at Teresa back there. I'm assuming you're going to see that on I-940, that you're going to see the extremes united. This, once again, tells you the importance of having a national political voice for police. A political voice that, if it were up to me, would be completely unaligned with any political party and would instead hold both political parties to answering the question, what are you going to do to improve my wages and benefits, as a condition of their support. Okay. Now, on to just a few themes in the case law that I'm seeing right now. Some of this is kind of interesting and good for you. Some of this is not so good for you. Let's start with the free speech cases. They're dreadful. The Supreme Court, about 6 years ago, 8 years ago, decided a case Garcetti versus Sabalos, and it revolutionized First Amendment law in this country. The facts of the case were pretty simple. It's an assistant district attorney down in Los Angeles County who believed that a deputy sheriff with whom he worked was committing perjury in search warrant applications. So the assistant district attorney wrote a memo about it, sent it through his chain of command, and ends up getting transferred as a result, a disciplinary transfer. And a transfer in LA County can be a big deal. It can be transferred 50 miles away from your home and still be in Los Angeles County. He sues. The court assumes, the Supreme Court assumes in Garcetti that he was transferred because of his speech, his writing this memo, this whistleblowing speech. And the court says, ordinarily, speech about whether or not a public employee is being dishonest, ordinarily that would be accorded the highest degree of constitutional protection. It's whistleblowing speech, it's speech about a matter of public importance. But Sabalos, this assistant DA, when he wrote that memo, he wrote it as part of his job. And we are announcing a new rule that any speech, written or oral, by a public employee made as part of their job has no constitutional protection whatsoever. Even if true, even if it's whistleblowing speech, it has no constitutional protection if it's speech made out of the job or that arises out of the job. And we have, in the wake of this Garcetti decision, seen very consistent decisions from federal courts, state courts around the country applying Garcetti to situations that you wouldn't believe. So, for example, what if a police officer goes into internal affairs, is given a Garrity order, and testifies truthfully as to something that has occurred involving another officer? Does the First Amendment shield that officer from being fired for the truthful testimony? Under Garcetti, you ask the question, is it part of the job of a police officer to testify truthfully in internal affairs? Yeah. Answer, speech is unprotected under the First Amendment. And there's half a dozen cases that have exactly that factual context. One that's always been particularly poignant for me is two majors in a small city in Oklahoma called Bartlesville, Oklahoma. These two majors are in a department that is being investigated by the Oklahoma Attorney General's office. And the investigation is a corruption investigation. It's low-level corruption, you know, the mayor is using prisoners to cut his lawn, and the police chief has been fixing tickets for friends. It's low-level corruption, but it's still, the AG is doing this investigation. The AG asked the two majors to come in and give testimony about what occurred. They did. They testified truthfully. They're fired. The federal court says, is it part of a police officer's job to cooperate with a criminal investigation conducted by a sister law enforcement agency? Yes. Answer, speech unprotected. What's so poignant about that case is they're not like you. They're not covered by collective bargaining agreements, where you have the ability to protest unfair discipline through a grievance procedure, or even if you don't have that, where you have a civil service system. They're not like you. These are police majors in Oklahoma. They have no rights to the job beyond the First Amendment. And the court just told them, you don't have any First Amendment rights. They lost their jobs for testifying truthfully in a criminal investigation. These cases, the only reason I have this up here is I try to read all of the published police employment cases decided in the country. I read about 25, 35 cases a day. And we are now in a run of these free speech cases where police officers are suing, saying that free speech rights have been impeded by the employer. And officers lose well over 95% of these cases right now. And they lose them at the outset of the litigation. They lose them in a procedural posture known as a motion to dismiss. What this does is to tell all of us in the room, we need to make sure that the disciplinary protections we have in our collective bargaining agreements are as sound as they possibly can be. Because we're not going to have any luck in the federal courts. I'll get back to the federal courts in just a minute. Okay, cell phones. The law continues to evolve on the issue of cell phones. And by the issue of cell phones, I mean, if you got one of these that you own, a personally owned cell phone, under what circumstances can the employer examine the contents of the cell phone? And this is an issue that arises with increasing frequency as officers are carrying cell phones on the job all the time. And the result is the cell phones are used associated with the job, which means it may be evidence in an internal affairs investigation. So employers are more and more and more wanting to see cell phones that are carried by officers. And the question is, do officers have privacy rights in the contents of their personally owned cell phones? We know they don't have any privacy rights if it's an employer-issued phone, right? We know that's the case. But if it's the officer's personal cell phone, are there privacy rights? And the answer seems to be, it's an evolving answer, the answer seems to be yes. So here's how we get to that answer. We start with a Supreme Court decision 3 years ago called Riley versus California. And this is a criminal case that comes out of San Diego. Riley is a gangbanger type who is stopped by the police. They have probable cause to stop him. They do a search incident to an arrest, to the arrest of him, and that turns up his cell phone. They examine the contents of his cell phone and find some text messages that associate him with gang activity. One thing leads to another, and he is prosecuted for attempted homicide. He files a motion to suppress his cell phone, saying, Fourth Amendment, you need a warrant and probable cause to get into my cell phone. The prosecution's answer is clear. It's a search incident to an arrest. It's an exception to the warrant and probable cause requirements of the Fourth Amendment. We can simply access the cell phone. The Supreme Court, in one of its extraordinarily rare 9-0 decisions, says Riley is right. The court says that cell phones are unlike any other property that we own. Other property might well be subject to a search incident to an arrest. But cell phones, the court says, have a status on, if you think of a range of the protection given to different property, on the low end of the range might be, for example, keys that are in my pocket if you stop me. The high end would be my home. Cell phones are at least where our homes are in terms of the privacy protections that they earn under the Fourth Amendment, if not more so. Because cell phones, I'm quoting here from the court's opinion, contain the most intimate details of our private lives. They are the electronic equivalent of our photographic albums, our mail, our bank records. We have 101 things that cell phones contain. Therefore, government, when you want to get into a cell phone, you have to have a warrant and probable cause, says the Supreme Court. Well, that gave us an answer in a criminal case. How do these criminal principles transfer into the law enforcement workplace? And typically, the way they transfer it over time is instead of needing probable cause, the employer needs reasonable suspicion to, for example, examine the contents of a locker or whatever it might be. And instead of probable cause that a criminal statute has been violated, it's reasonable suspicion that a disciplinary rule has been violated. That's typically the way these Fourth Amendment principals who transferred into the workplace. Well, what's happened to cell phones since Riley? We now have 4 decisions involving cell phones, 3 involving police officers, 1 involving a firefighter. The one involved the firefighter only came down 2 days ago, so a pretty recent case. And the theme seems quite clear. The courts are applying Riley in the law enforcement workplace. They are saying, employees, you have to have a reason to look at the cell phone. And most importantly, I think, if you're going to look at a cell phone, the contents of a cell phone, let's assume you have the reason, your search has to be limited to that reason as narrowly as possible. That's another basic Fourth Amendment principle, right? If you're going to do a search, you can find the search probable cause that gave rise to the need for the search. Same thing, you do the least intrusive search that you can. So if you're going to do a search of a cell phone, and the allegation is that on September 10th, 2018, the cell phone was used to send sexually suggestive text messages to another police officer, that means you can, employer, look at the cell phone's text messages from September 10th, 2018. But not the photographs from that day, not the text messages from any other day, not the email from any day at all. You confine the search to the reason for the search. Most careful employers right now are actually not doing the searches of cell phones themselves. They're farming it out. They're sending it to some sort of forensic analyst, saying this is what we want, and this is the only information that we are authorizing you to report to us. So how does this play out? I think the most interesting case is one that comes to us from the Port Authority of New York and New Jersey. It's a case that's about 10 months old now or so. You know the Port Authority has a large police department, right? They police the airports in New York and the various, and New Jersey, and the various ports, and as well the World Trade Center areas, some other areas. They have a large police department. Well, they had a graduation party for a bunch of recruits. And usually when a lawyer starts off a sentence with a graduation party for recruits, it's not going to end well, right? And this one doesn't. So they go to one bar in New Jersey, and that doesn't end too well. So they go to a second one, I think it's called the Cactus, Arizona Cactus Bar and Grill. And they behave badly enough in this place that the bouncer later testifies that it was the worst night of his life. And you can just imagine the various activities that went on. The department has called, an internal affairs investigation was started, and the recruits are brought in. There's 61 of them who are brought in who use their cell phones to use a meeting app, right? It was WhatsApp or something like that, to organize where they were going to be drinking. They get called in. They're given Garrity orders. So they're told, you know, you must answer our questions upon pain of job forfeiture. You got to answer truthfully. Given Garrity orders, and then they're told, we'd like to see your cell phones. You don't have to give them to us, but we'd like to see them. They produce the cell phones after all their recruits. They produce the cell phones. Union sues. Federal court says this case is going to go to trial. First of all, in order to see the cell phone, you need probable cause. She doesn't even use, this judge doesn't even use the reasonable suspicion standard. You need to see probable cause. We don't see, the judge says, any probable cause that you have, that you've articulated, employer, that allows you to get into the cell phone. So we think this is a matter for the jury. And employer, as to your argument that this is a consent search, that these recruits agreed to give up the cell phones, we have to consider the context. These are recruits who are essentially at-will in the police. You've just given them a Garrity order, and then you said, please. Well, a reasonable jury could conclude that the please was totally infected by the Garrity order and their at-will status, and that this was not a voluntary decision on their part to turn over their cell phones. That case has been to a trial right now. So, the object lesson in all of this for all of you in the room is, if you've got an internal affairs investigation that's going on where the employer wants to see a cell phone, get in touch with your lawyers right away. They should be ready to go with a motion. It depends on where in the procedure you are, but it would look something like an application for a temporary restraining order to prohibit the employer from getting into the cell phone. Second object lesson on the cell phones is train your employees never to use their personal cell phones for company business and never to use their company cell phones for personal business. If you use your personal cell phone for company business, we know now, thanks to the Washington Court of Appeal and the unending saga of the Pierce County prosecutor, thank you, we know now that if you use a personal cell phone for employer business, you're creating a public record. So don't do it. Why would you subject your phone to potential analysis? And we also know that if you're using your company cell phone for private business, you have no expectation of privacy. So, two cell phones. And, you know, I've had some officers who listen to me say this, saying, well, our employer doesn't provide cell phones. And my answer is a cell phone, does your employer think that a cell phone is an essential piece of law enforcement equipment? Of course, if they're requiring it, yes. Why are you paying for it? Why shouldn't that be the employer's obligation? Yes, sir.
So which cell phone do I use to communicate with my union attorney regarding union business as a guild board member?
Your personal cell phone.
That's what I do, but
yeah, your personal cell phone.
The courts recognize that there's a line or there's a difference between my being an employee of the city versus a guild or union member.
Yeah, I would use your personal cell phone. I think you're going to be protected. Okay, other questions about that? Okay, next up, consent decrees. We've all seen the disaster of Seattle, right? With respect to consent decrees, that union, for some, at least not publicly disclosed reason that we know of yet, that union decided when the consent decree process started that it was not going to try to intervene in the consent decree proceedings. There was a Ninth Circuit, there is a Ninth Circuit case right on point involving the Los Angeles Police Protective League, where the Ninth Circuit held that if a consent decree potentially impacts a collective bargaining agreement or collective bargaining rights, the union has an absolute right to intervene. Seattle chose not to do it. We've all watched from the sidelines as a federal court judge has basically put enough pressure on the process that they've rewritten the disciplinary proceedings in the contract in a way not favorable to Seattle police officers. This tentative settlement of the contract that you've seen in Seattle, among the features of it, there's many disciplinary features. Among the features of it is the union ended up giving up a clear and convincing standard for burden of proof in disciplinary cases. That had been in the collective bargaining agreement. They gave it up. That was the focus of the consent decree discussions. So stay on the sidelines at your risk in consent decree proceedings. There's other lessons like that from all over around the country, and plenty of lessons to the contrary. You know, when LA got involved in the consent decree, when the Portland Police Association got involved in the consent decree, they were able to influence the eventual results of the consent decree. So plenty of examples to the contrary. What's going on right now, you might think consent decrees, well, that went out the window with the Obama administration. Jeff Sessions' Department of Justice isn't interested in consent decrees at all. But you're forgetting that we have state attorney generals out there who have the right to bring lawsuits with respect to consent decrees that look a lot like DOJ lawsuits. And that's what's happening right now in the Chicago Police Department. You recall that when Jeff Sessions took over as AG, he shut down a long-standing DOJ investigation into the Chicago Police Department. DOJ had issued 2 reports. They were the worst reports I've ever seen for any of these DOJ reports in any city. They explicitly accused the city of racial bias, not only with respect to policing, but also with respect to the application of non-deadly and deadly force. These were incredibly condemnatory reviews. And when the DOJ just simply closed up shop without filing a federal court lawsuit, the activists in the state regrouped. They convinced the state attorney general to bring a lawsuit. The lawsuit was brought in August of 2017 that looked every bit like the DOJ bringing a federal court lawsuit itself. The lawsuit immediately progressed into negotiations for a settlement agreement. The suspicious amongst us might think that a deal had been cut as to what the consent decree was going to look like. The consent decree is announced in the first part of this year. Before it's not officially the consent decree, but they're starting to hold community meetings on what it is going to look like. Finally, the rank and file union for Chicago police officers wakes up. This is the Fraternal Order of Police. They wake up, they file a motion to intervene in the lawsuit in June of 2018, so 10 months after the proceedings have started. And the federal court 2 weeks ago said, too late. The train has left the station. Your time to intervene was when the lawsuit was filed. You don't sit on your hands while the negotiations are going on. I'll listen to you. I'll listen to you like I'll listen to any other person off the street who has any input to give me on this consent decree, but you may not have party status. So consent decrees haven't gone away. You got to watch out for them coming from a different point of view. Last thing, Brady. This is good news on Brady. I mean, first of all, congratulations to you guys, and in particular, I keep picking on Chris because he's just front and center, particularly Chris. Chris came to an LRIS seminar like 4 years ago or something like that, and saw that California had passed an amendment to their Peace Officers Bill of Rights to deal with Brady. And the amendment to the Bill of Rights says you cannot be disciplined simply because you've been placed on a Brady list without proof of the underlying dishonesty. And through, I think, I mean, I'm sure the work should be attributed to lots of people in this room, but I think through Chris bringing it up and being as a tenacious guy as he is, you got it passed in Washington. You got it passed with a Democratic House, a Democratic Senate, and a Democratic government. I mean, it's quite an accomplishment. You're only the 3rd state in the country that has that sort of statute. Maryland includes the other 1 states. Without regard to the statute, you are seeing lots of arbitrators' decisions and court decisions right now that are a huge pushback against what I think of as the harshness of the Brady rule. We're seeing 2 developments, one of which I never thought I would see. And that development is we are seeing arbitrators in courts draw gradations in untruthfulness. It used to be that a lie was a lie was a lie, right? And the lie was, in particular, the main capital offense for a police officer. And now we see, because of the Brady implications of the finding of dishonesty, we find arbitrators in courts saying, you know, there are lies about something that affects the civil rights of another individual. There are lies in official court proceedings or court testimony. And then, you know, there's kind of making up a story about why you're late for work one morning. And those two aren't the same for Brady purposes. And you don't need to put someone on Brady list for minor transgressions with respect to untruthfulness. Who would have thought they would see something like that? But that's because of the harshness of the Brady rule. The second thing that we're saying is the continuation, with respect to Brady, the continuation of officers unsuccessfully suing prosecutors for damages for being wrongly placed on a Brady list. By far the worst decision in this area comes out of Oregon. It's a Ninth Circuit opinion now. This is a case involving a sergeant in the Seaside Police Department in Oregon. And the sergeant is running for sheriff of the local county, Clatsop County. The district attorney in Clatsop County doesn't like the sergeant. So he writes an "in my opinion" piece in the local paper that says, this sergeant is bad, and you shouldn't endorse him. I don't need to go into what he said about it. You should not support him for sheriff. The sergeant decides, well, you know, the DA's up for re-election. So he writes a letter to the editor saying, the DA is bad. You should not support him in the election. The DA responds by putting the sergeant on his Brady list and saying, I will never call him as a witness. The sergeant ends up resigning his job because of it, facing termination. And the sergeant sues the DA. And the Ninth Circuit says, you know, where this case is, procedurally, we have to assume everything the sergeant said is true. We have to assume that the DA put the sergeant on his Brady list for purely political purposes. It's an act of political retaliation. And the sergeant has no claim against the DA because of the principle of prosecutorial immunity. Prosecutors have absolute immunity without regard to their motivation for engaging in acts attendant to the prosecution of crimes. Period. End of issue. Doesn't matter why the prosecutor put the sergeant on the Brady list. So when you see cases like that, that's why your statute that you now have in Washington becomes even more important. Okay. Questions about any of that before I move on to Janus? Maybe you want to cover yet one more Brady case that is out there that's a pretty interesting one. It's sort of a glimmer into how you can challenge being wrongly placed on a Brady list. And by the way, I talked about a fair amount of cases this morning, and I realized you don't have any of the citations or any of that in the material. If you want any of the cases that I have described, just email me, and I assume you've got my research.
We know where to find you.
Yeah, know where to find me. And just give a rough description of the case, and I'm happy to send you the cases. Okay, the one I'm about to talk about right now is something called the Duchesne case, D-U-S-C-H-E-N-E, and it comes out of New Hampshire, and it's the first case in the country where police officers, to my knowledge, have been successful in suing not to get damages from the prosecutor, but to be removed from a Brady list. So here's what happens in the Duchesne case. These are a couple of police officers who are involved in an off-duty fracas at a bar. That results in both a criminal investigation and a disciplinary investigation. The local DA decides that he's got conflicts of interest, he can't do the criminal investigation, can't oversee it, so he sends it to the state AG. The internal affairs investigation, meanwhile, just continues to percolate. The AG finishes first. AG says, no basis for criminal charges, I'm done. All we've got left is the internal affairs investigation. The result of that is 2 sustained charges for each of the officers, excessive force and dishonesty. And they get a 30-day suspension. this to me is probably the most unusual feature of the entire case, is that in New Hampshire, you can have a sustained charge for excessive force and dishonesty and not get fired. Pretty interesting. Anyway, they challenged, the two officers challenged the suspensions in arbitration, and they win. The arbitrator says, hey, in the bar was an excessive force, that was self-defense, they did nothing wrong. And secondly, they didn't lie about it, reinstate full back pay. We're all done, right? Criminal case over. The disciplinary case is over, except that local DA, the one who initially washed his hands of the whole thing and sent it to the AG's office, said, I know what happened in that bar. And in fact, they were the aggressors, and they did lie about it, so I wasn't on Brady. And I won't call them as witnesses. And the officer sued and came up with really an ingenious legal theory that now I'm trying to publicize as much as I can, and it's been used now in other places in the country. And the theory is that the state Supreme Court is the ultimate arbiter of the fairness of what goes on in the justice system in the state. It's the ultimate supervisor of the justice system. And with that comes an element of due process with respect to the rights of those participating in the justice system. And the New Hampshire Supreme Court says what happened here with the prosecutor doesn't meet that test for due process, and orders that the prosecutor begin to use the two officers as witnesses. First case I've ever seen an officer successfully sued to get off the Brady list. And the key was they didn't sue for money. Prosecutorial immunity wasn't part of that. Instead, they sued to be removed from the list. So, a little bit of a glimmer there in terms of officers placed wrongly on the Brady list. Okay, now let's get into Janus. I'm going to run through the history of this relatively quickly because I think most of you have already know this. The Janus decision, all about what's known as fair share. And fair share is a notion that existed under statewide collective bargaining laws. And what the law said was, look, unions are the exclusive representative for members of the bargaining unit, and you are able to negotiate for a clause in your contract that either says to employees in the department, you must be a member, or if you choose not to be a member, you must pay your fair share to the union of the cost of negotiating and administering the contract from which you benefit. And so you have this two-tiered system of union dues. Those who wanted to be full members, in law enforcement, that's typically 100% of the bargaining unit. Those who wanted to be full members, and then those who said, I don't want to be members, but still got the benefits of the contract, they would be fair share members. And their dues would be less, because their dues would only be that amount of the union's expenses that were associated with negotiating and administering the contract. Fair share dues typically were around 85% or so of full dues. It's extraordinarily rare in my career to find someone who wanted to be a fair share member. Every once in a while, you'd see someone pop up as a religious objector who would say, my religion prohibits membership in a union. Usually that's someone who is a Jehovah's Witness. And those people, under the statute in Washington, there's a citation to it, those people could pay the amount of union dues to a non-religious charity. Occasionally that would pop up, but we didn't see very many fair share cases. I think I've only ever been involved in one, and it involved the Troopers Union here in Washington. So that's fair share. Early on, the Supreme Court of the U.S., 1977, early on, as statewide collective bargaining laws are being passed in the 1960s and the 1970s, the Supreme Court considered the constitutionality of fair share. There were some teachers in Detroit, in this case called Abood versus Detroit Board of Education. There were some teachers who challenged the constitutionality of fair share. They said, look, if you force us to pay money to a union, that is forcing us to associate with the union. The First Amendment has a freedom of association. you can't force us to do so. Not only that, the union is engaging in speech on matters of public importance by default when it's negotiating a collective bargaining agreement, a public sector collective bargaining agreement. That's a matter of public interest. That's the expenditure of public funds. You are, by forcing us to pay money to the union, you're forcing us to engage in speech, and the First Amendment prohibits forced speech. The Supreme Court unanimously upheld the constitutionality of fair share in the face of those challenges, and ended up saying, look, we've just got to balance it. No constitutional right is absolute. Free speech rights aren't absolute. We have to balance the competing interests here. And the competing interest that we're balancing is free speech and freedom of association on one side, and on the other side, the free rider problem. And the free rider problem is that without fair share, people could choose to be non-members of a bargaining unit and demand a duty of fair representation from their union. That a duty of fair representation that would cost money for the union to discharge. And so the cost of representing non-members would then be borne by everybody else in the union. And the free rider problem has become more poignant as we've gotten much more litigious in the labor sector since 1977. These cases become much more involved. The last discharge case that I handled in Portland, which I handled about 5 years ago, 6 years ago or so, it was a termination case for an officer who was alleged to inappropriately use deadly force against an unarmed suspect. That case went to arbitration, took 14 days to try. The union got so upset about it that it filed a Public Records Act request and learned that the city's lawyers' attorney's fees for a simple termination case were $800,000. And so these cases, of course, union side fees are never going to be what the employer side fees are. Union side lawyers get paid less than any other kind of lawyer. Got four of them right here. You guys have been divorced. You know the truth of what I speak here. But at any rate, they're not going to be nearly that. But you have 14 days of hearing, you're going to have a significant expense. So this whole issue of the free rider problem has gotten more and more poignant over time. So what happens after a boot? What happens is the Supreme Court changes its politics. And we have, by the second decade of the 21st century, we have a Supreme Court where we have a 5-4 split on labor issues. And it is a very clear-cut 5-4 split, and the impact of it is incredible. Some of you have heard this before. I actually try to track Supreme Court labor cases and which way they come out. So when you look at management versus labor, or employee versus the employer, who wins in those cases before the Supreme Court? And my current count is that in the last 13 years, we have had 83 Supreme Court decisions involving employers against either unions or employees. 83 Supreme Court opinions. Employers have won 79 of those 83 decisions. One of them is a tie, and unions have won 3. That is not an accident. That is an ideology. That is at work, right? And most of those decisions are 5-4 decisions of the Supreme Court with the same 5 justices in the majority. It's just been a lot low. We've now grown up with this notion of a divided Supreme Court. It's kind of interesting if you look at it historically. Over time, since we've had a Supreme Court, this is a rarity. Usually the Supreme Court speaks with one voice. Usually politics are not supposed to infect the Supreme Court. And we've seen incredibly difficult decisions made by the Supreme Court on a unanimous basis. Think Brown versus Board of Education, in which we had our first move towards desegregation of public school. That was a unanimous decision. Can anybody imagine a Brown versus Board of Education being a unanimous decision today. I mean, you just don't see that. So we start to see this huge division, and we start to see the justices taking shots at the Abboud decision. And one of the more important of those shots was in this case in 2012 called Knox versus SEIU. This dealt with a minor issue of what happens when you have a union that makes a mid-contract assessment. Does it have to give non-members a new breakdown of chargeable versus non-chargeable expenses to determine the fair share percentage? That's kind of a minor little issue. But the court on its own, that's what the phrase sua sponte means, on its own raises the question of whether Abboud is still good law. Nobody had thought about it. And the court is raising this issue on its own. Doesn't decide it, because it hasn't been squarely presented by the case. But all of a sudden, everybody knows that Abboud is on this Supreme Court's radar. Then we get to Harris versus Quinn in 2014. The Supreme Court again ducks the issue of Abboud in a case involving whether home health care workers have to pay fair share. Instead, it says home health care workers aren't really employees, so there's no ability to even charge them fair share. But they basically invited a challenge to Abboud. Once again, invited a challenge to Abboud. Then next up, we have Friedrichs versus the California Teachers Association. This is where we thought, first of all, that fair share would end. This is in 2016. This is a pure Abboud case, and the question was whether Abboud was still good law. Oral argument was held in this case in January of 2016. 4 of the 5 justices in that conservative majority all commented from the bench, saying they thought that Abboud needed to be overturned. The 5th justice, Justice Thomas, said nothing, but that shouldn't surprise you if you follow the Supreme Court. He actually went at one point 12 years without making a comment from the bench during oral argument. He just broke that last year with that 12-year term. So he just tends not to talk during oral argument. Some of us very much appreciate judges who don't talk. I tend to like judges who talk, so that's right. But in any case, 4 out of the 5 said we think Abboud is not good law. We were all going out there saying, look, by the end of the Supreme Court's term, fair share will be illegal. And then the next month, February 2016, one of those 5 justices, Justice Scalia, dies. You end up with a 4-4 split on the court. When you have a 4-4 split, the lower court's opinion is upheld. The lower court ruled that fair share was still constitutional. That's what the Ninth Circuit said. So fair share lived for another day. It lived until we have this change in the Supreme Court. These were the 5 justices who were in the majority in those 5-4 decisions that I was talking about. Red indicates whether they were appointed by a Republican president. Blue indicates whether they're appointed by a Democratic president. And so you see the split was a party line split. I will tell you from the standpoint of being a lawyer who loves the law and loves the Supreme Court, this is shameful, right? This should not be happening. And yet that's where we are today with respect to our justice. Of course, we have the change where Scalia's out, and we have Neil Gorsuch who comes in. Neil Gorsuch is, so far, his track record has been more conservative than Scalia on labor cases. And by the way, if you think Gorsuch is conservative, we now have Justice Kennedy retire. We're in confirmation hearings for someone who could be Justice Kavanaugh. Justice Kavanaugh would be the most conservative justice on labor cases based on his track record in 80 years, since we have the justices who appointed, who opposed the New Deal in the late 1930s. So we have this change. We now have a reconstituted 9-member Supreme Court, and We have a political philosophy coming down from the president who is making these appointments. President Trump is on the record as having said that he believes in right to work. Right to work means, all right to work means is that a non-member in your bargaining unit should not have to pay you any dues. That there should be no fair share. That's what right to work means. We have also learned from the president that his judicial appointments are being made on a list that has been provided to him by the Federalist Society. This is not even an open secret. It's not at all a secret. That's where he appointed Justice Gorsuch from. That's where he appointed Sue to Justice Kavanaugh from. The Federalist Society, what is that? That's yet another Koch brothers funded organization. This is one that gets involved in the judicial system, and they are responsible for the court of appeals appointments that you've seen, the federal court appointments. They're the ones providing this. So it's likely that this split that you see is going to remain as it is. It could become more profound depending upon whether any other justices in the court we could get to a 6-3 or 7-2 split on labor issues by the end of President Trump's term. So, at any rate, this gives us Janus. This comes down on June 27th of 2018. Overturns a boot on a 5-4 margin. Says the boot was wrongly decided from the first moment. And therefore, the entire country is converted into a right-to-work country. Fair share payments become illegal. In the course of the opinion, this is written by Justice Sam Alito. It's a bizarre opinion. Anybody in the room actually read Janus, the opinion? You have? Okay. I hate to call it recreational reading, but it really is a strange opinion. It is much more like a political speech than a court opinion. It's not, it's very odd that the opinion spends half of its time, over half of its time, dealing with a non-issue, something that doesn't relate to fair share, something called particular investment. And it's nothing more than repeated shot after shot after shot at labor unions that come from the pen of Justice Alito. He says a boot's wrongly decided, so we don't hesitate to overturn our cases that have been wrongly decided. In the course of it, he addresses the free rider problem. He says, what about the free rider problem? What about the representation of non-members? Why do unions do this? And he says unions want to do this. And the reason they want to do it is they want to protect their contracts. The resolution of one employee's grievance can affect others. So therefore, the free rider problem is no problem at all, because this is an obligation that unions should want if they don't want it. Well, the impact of Janus is quite clear. Immediately, fair share is illegal in this country. And what that does is to give everybody what I think of as a bunch of decision points for both employers and unions. So let's go through those decision points. First of all, do you have an illegal fair share clause in your collective bargaining agreement? If you do, you probably also have what's known as a savings clause in your collective bargaining agreement. That's one of those clauses at the end of the contract you never read that says that any clause in this contract has been rendered inoperable by decision of the court, then you will agree to negotiate a substitute clause. So both unions and employers, you've seen both of this, will reopen contracts to get rid of illegal fair share clauses in collective bargaining agreements. That's a pretty obvious dues deduction and membership clause issue. Second thing, decision point for Janus. Many of you have in your collective bargaining agreements an obligation that the union defend and indemnify the employer with respect to fair share or dues deductions. You need to get rid of that as well. anything from dealing with fair share needs to be stripped out of your collective bargaining agreements. Third, for unions, you may well have, you should have, because it was required, you may well have in your bylaws or your constitutions fair share provisions. You'll need to get rid of those as well, because once again, they're just simply unenforceable as a matter of law. While you're up, okay, while you're amending your constitution or your bylaws, do a line-by-line review of your constitution and bylaws. Take that opportunity to do it. Make sure it's up to date. Make sure that it reflects what your practices are. Run the constitution and bylaws by your attorney to see whether or not they've got any suggestions for you as to what you might be, what you should be looking for. I have a company called Labor Relations Information System. We published a book called Running a Public Safety Union. We have sections in there on constitutions and bylaws. Consider picking up that book and comparing it to your constitution and bylaws. We don't do this enough, right? We don't update our bylaws nearly enough. And bylaws are a legally enforceable contract between you and your members, so you want to make sure they say exactly what you want them to say. What about employers taking the position that those dues authorization cards that employees sign pre-Janus, that they're not valid, and that all employees need to sign new authorization cards in order to, for the union to get its dues? The Association of Washington City seems to be taking a rather aggressive position on this, suggesting that employers take this position. This is not at all required by Janus. It's not constitutionally obligated. And I'm guessing we're going to see litigation resulting as a product of this. You may want to do this voluntarily. I mean, you may want to go to all your members as part of what I'm going to talk about in a moment, which is your post-Janus outreach to your members. You may want to do this. Go get the new cards and solve this problem. But there are some places right now where we're already seeing litigation over this issue. And in fact, in Washington, I'm sure you know about this, there's 2 lawsuits that have been filed at a statewide level saying, or arguing, and they're filed by the usual suspects here, you know, the Right to Work Foundation out of Virginia. And those lawsuits are claiming that pre-Janus authorization cards aren't valid. Some of you, I'm confident of this, never had your people sign authorization cards, students' authorization cards. It just never happened for whatever reason. You do need to make sure you have authorization cards on file before everybody. Okay, questions?
No question.
Yeah.
And if this isn't the right place for this, feel free. But we had a discussion with our Clark County, Washington Deputy Sheriff's Guild. And if an individual was hired, and for us, it's always been your guild affiliation is a condition of employment. So we didn't fill out a card. It says on your job offer it's a condition of employment. If someone was to opt out of that and say, we don't need your guild for anything, right? They just want to be a right to work employee.
Right.
And we had a discussion with our attorneys when we come up for contract negotiation next year, and that individual, how does that individual vie for a wage increase on their own? And if they did, general consensus was if they received a wage increase equal or greater to whatever our contract would be, that obviously that would directly affect that. And do you see that as something that's potential? Because I definitely see at some point somebody is going to join a law enforcement organization and say, I don't want to be a part of this organization, I'll do it on my own.
Yeah, and there's, everybody hear that question? There's about 4 questions buried in there, all of which are like really important. The first thing is, can an individual say, I'm going to negotiate my own contract. I don't want to be a member of the union, and I don't want to pay anything to the union. I don't care for any union services, so I'm going to negotiate my own contract. Can an individual do that? Well, we've had them, there are right-to-work states that have had collective bargaining for many, many years. So Florida, for example, is a right-to-work state where there's collective bargaining. California actually has an odd provision in state law that seems to give the right to people to negotiate individual contracts. In spite of any of that, courts have very consistently held that since the collective bargaining law designates the union as the exclusive representative for the members of the bargaining unit, there is no ability for anybody else to negotiate a contract. It's this principle of exclusivity that's built into the collective bargaining laws that is so important. Now, what if, for example, that didn't exist? What if that principle of exclusivity didn't exist, and your guy went in and got 10% more than everybody else? What would I be doing if I was representing your union? I'd be filing a lawsuit against the employer, unfair labor practice, contending they were discriminating on the basis of union participation in the award of the wage increase to the non-union person. But I don't think you ever get there in Washington because of the principle of exclusivity. Okay, what else should everybody be doing, or where are the decision points? You need to be reviewing your dues deduction cards if you haven't done that yet, because you'll need to strip out any reference to fair share in your dues deduction cards. Many of them would have a choice, where you could say full member, fair share member, and you can handle all of that. If you have, anybody here have fair share members? Have you had? You have one? You would notify that person that there's no longer going to be fair share and they have the right to opt out. They immediately rejoin. Now, some employers are taking the position that they have an affirmative obligation to notify employees of their right to opt out of union membership. So far, I haven't seen any employers actually do that, but I've seen employers threaten to do it. And the response from unions has been, when employers threaten to do that, is if you dare do that, that is going to be an unfair labor practice. You can't communicate with our members, at least implicitly arguing that they should get out of the union. And I've seen employers back down from this. I don't think that's going to be too much of a problem. It's one of these things that we saw in a week or two after Janus, when employers were really sturdy with respect to it. And then here's the big one. You want to revise your collective bargaining statute, or in some places, people bargain under local collective bargaining ordinance, not in Washington, but in other states. You want to revise your bargaining statute to somehow deal with the free rider problem. And how would you deal with the free rider problem? You could go with two systems. You could go with eliminating the duty of fair representation for non-members. So you simply say, the union owes no duty of fair representation to non-members. You amend the statute 4156 to say that. Is that legal, by the way? Sure, the duty of fair representation is a creature of statute and can be amended by statute. So you could say that constitutionally. The second thing you could say is that it is not an unfair labor practice complaint for a union to adopt what people are referring to as a pay-to-play system. And pay-to-play, this is a phrase I think actually my partner, Neil Tarry, came up with. I love it. And it's gotten kind of infectious. A lot of people are using it. What's pay-to-play? You can be a non-member if you want. But then if you call upon us to provide services to you, you have to pay the fair market rate for those services. And so here's language that we have drafted with respect to pay-to-play, at least the first half of this. This language actually incorporates both those concepts. The pay-to-play concept is not an unfair labor practice or a violation of the duty of fair representation for a union to charge a non-member reasonable costs or fees for representation unrelated to the negotiation of the collective bargaining agreement. Get back to that, and that's the pay-to-play fees. We eliminate the duty of fair representation as the rest of it, or to deny non-members union representation altogether. So let's go back to pay-to-play for a moment. Why does this pay-to-play, why is it limited to costs unrelated to the negotiation of a collective bargaining agreement? It's because Alito's opinion in Janus makes it clear that where a pay-to-play system would be legal, he actually refers to this, a pay-to-play system. He says it would not be legal for the negotiation of the collective bargaining agreement as a whole. It would rather be for point of sale representation, such as I've got grievance, I can discipline, something like that. So this is language that captures these two concepts, and we need to have a discussion about those two concepts. But before we do, let me just finish up the chart, okay? And to say that if you are going to contemplate a pay-to-play type system, you'll need to amend your bylaws or your constitutions to describe what those systems look like. And in our firm, we've drafted sample language that I'm happy to send to you guys, and you can run by the lawyers and have them check where you can get a pay-to-play system into each bylaws. So this is, by the way, Alito in Janus on a pay-to-play system. He indicates that individual members could be required to pay for that service or could be denied union representation altogether. So you see the two halves of the notion that are buried right in Alito's opinion. Yes?
It says could, not shall.
No, it's not as a matter of law. You have to restructure the collective bargaining law to do that. That's where you need the amendment.
Can I ask a quick?
Yeah. Yeah.
So back a couple of slides where you were talking about reviewing the statute or ordinance, that you're referring to whatever within our city government or county government, the ordinance that addresses negotiations.
No, actually, in your, what jurisdiction are you from?
Here, Chelan County, Mass.
Okay, no, I'm referring to RCW 4156.
Okay.
This would have to be a change to the state law collective bargaining law. Your city or your county's ordinances wouldn't be.
Oh, okay.
Yeah. This is a walkouts issue. This is the core walkouts issue. Do you want to go to either of these? And I will tell you, unions are all over the map on this issue. Traditional labor unions, the ASMEs, the SEIUs, the Teamsters of this world, seem to be opposed to both of these concepts. Pay-to-play, eliminate the duty of fair rep for non-members. They seem to be opposed to it. They take I think, a very collective approach, one for all for one, and they think that it's just too dangerous to tinker with collective bargaining laws to allow this. They are particularly worried about denying the duty of fair representation to non-members. They're less worried about pay-to-play. The reason that they're worried about denying union representation to non-members altogether, eliminating the duty of fair representation for non-members, the reason they're worried about that is they think that implicitly attacks the notion of exclusivity, that the union is the exclusive representative for employees. And in fact, that's what Anil and I feel as well. We're very worried about that option. We don't recommend that option. If you want to go one of these two routes, we think the way to go is pay-to-play, because that doesn't attack the notion of exclusivity in the same way that denying the duty of fair representation, turning it off for non-members.
So, under pay-to-play though, how do you, if the person comes and requests representation, maybe we have somebody who's opted out,
Yeah.
and then they get themselves in some shit, and they come to us and say, we want you to represent us, and we say,
Right.
okay, is there, if I'm understanding you correctly, we need to address specifically within our bylaws what circumstances we will choose to represent them or not choose to represent them, or is it a blanket, we're pay to play, if you request it, we'll provide it, but you're gonna pay us.
I like language that grants to the executive board of the union unreviewable discretion in whether to charge for the provision of representation. So
Whether
you
to
make
even
that-
charge, not the decision to represent.
No, well, the decision to represent, yeah.
Which is yes, then charge.
If yes, then charge. But complete discretion on everything. Because there may be a case that comes down where it's a non-member raising the issue, where you want to take that case without charging that non-member, where if you do charge the non-member's not going to pursue the claim. And then you have the problem of that infecting precedent for the rest of your argument. So you're going to want to have the discretion, I think, to represent non-members. You're also going to want to have the discretion to look at a guy or a gal who has not been a member of your union for 12 years, not paid you a cent in dues, who now has a 30-day suspension. You're going to want to look at that and have the discretion to say, okay, we're happy to let you 2 years. This is from Los Angeles Police Protectors, Los Angeles Police Protective Association. This is their pay-to-play section of their website. You go to their website and you can say that they've got so much per hour for the general counsel, for the paralegal, all of this sort of stuff. Built it into their system. I think if you want pay-to-play, if you want that as a notion, you can get over that hurdle. Then I think you're going to want to have the discretion to do all of that stuff. So make sure when you amend your constitution, you grant you as much discretion as possible. Yeah.
Do you see, I guess you kind of answered my question, but do you see that as a problem though, because you want the discretion to be able to, like you said, you don't want your sheriff to be able to discipline someone for a 30-day suspension, but not have the ability to go out and grieve that suspension. Do you see it as a problem though, picking and choosing what you grieve based on whether or not they pay or they pay or not, or as far as future lawsuits and failure?
No, if you amend the collective bargaining statute correctly, you're not going to have a unfair labor practice complaint, a duty of fair rep claim, if you charge for their services. And it is explicitly recognized in the legal opinions that that's an option. You just have to be careful in what you amend the statute. Now, we've seen this come to the fore already in one place, and that's up in Anchorage. We represent the police union in Anchorage, and they bargain under a local collective bargaining ordinance, and they hashed this out. And the end result was that, just kind of giving you the alignment of the different unions, the general employees unions didn't really want any change in the collective bargaining law. The firefighters didn't really care, and the police really wanted pay to play. And because the police have the most political influence there, pay to play is now part of the Anchorage collective bargaining statute. And my experience has been, just talking to individual police officers, that police officers are going to be the most supportive of the pay to play notion of anybody. Okay, but that's the WACOP's decision point. What do you want the collective bargaining statute to say? Do you want it to have, it would be a pay-to-play option. It's not an unfair labor practice for a union to have pay-to-play. Okay, just a little bit more from the webpage. You need to see that a bit more. Okay, what are other union strategies out there with respect to the fair share? First of all, you offer union members access to additional benefits. These can't be additional benefits that are mandatory subjects of bargaining in the law, because then you'd be discriminating between union members and non-union members over a mandatory subject of bargaining. So these have to be other types of benefits. So like disability insurance, life insurance, discount prices for goods and services, those things are all outside of the scope of mandatory subjects and bargains. So those are things that we're seeing unions offer as a package. The big thing that we're seeing are legal defense plans. Not legal defense plan, you're familiar with the two big groups that are selling legal defense now. It's PORAC and the Fraternal Order of Police. Both of them have three-tiered plans: civil defense, criminal defense, and administrative. When you see administrative, think discipline. When you see civil, think Section 1983 lawsuits. And when you think criminal, think generally OISs or any other criminal charges. So civil, criminal, and administrative. Administrative clearly is a mandatory subject of bargaining, right? It deals with discipline. So you could not distinguish between union members and non-members by offering only this coverage, this administrative coverage, to full members. Where the real action is with respect to civil and criminal that are probably not within the scope of bargaining. And we have seen numerous unions in the last 3 months go to purchasing either the FOP or more commonly the PORAC legal defense plans for civil and criminal. They're both relatively cheap. They're about $5 a month. The civil coverage is virtually useless, I will tell you. It involves a lawyer looking over the shoulder of your city attorney or county counsel, just making sure they're doing their job in a Section 1983 case. It's the criminal coverage, that's where the action is, that provides you with a group of attorneys who will respond to you, respond to officer-involved shootings, other critical incidents, other criminal charges that might be considered against your members. My experience has been so far that the group that's picking up a lot is PORAC, and FOP is not picking up a lot with respect to the legal defense plans. There is a storm that is brewing out there. And it's kind of complicated, so bear with me on this. PORAC and FOP have different structures to their legal defense plans. With PORAC, it will only sell its plan to a union. So Chelan County Deputy Sheriff's Association.
City of Wenatchee.
Oh, City of Wenatchee Police Guild? Okay, Police Guild. They will only sell to the City of Wenatchee Police Guild. FOP will sell its plan to individual members of the Wenatchee Police Department. It is very easy to predict that you are going to find some individual police officers and deputy sheriffs saying, what the hell do I need the union for? I can buy this coverage, this civil, criminal, and administrative coverage for less money than union dues. So I'm going to drop out of being a member of the union. The union still has to, negotiate a contract for me. I still benefit from that. And the union still files grievances on my behalf, but I'm going to go with the FOP for civil, criminal, and administrative coverage for half the price of union. Pretty easy to see that happening, right? And I think that is going to set up what I think of as a competition between the FOP, unless it changes its practices in unions. I think you're going to see the FOP be in a position of trying to decertify unions with the focal point being the legal defense plan. I brought this up with the National FOP. I told them we've got a major problem here that you need to confront. They say they are going to look at it, but I wouldn't put a lot of stock in that. So it's just something that you guys need to be aware of that's floating around out there that is a pretty important issue. Okay, last thing I want to give to you, and then I'll get off the stage. Yeah.
What's FOP? Why would they want to regulate it? That doesn't make sense.
Why would they want to do that? Well, first of all, FOP is not a union.
I understand.
And in fact, in their bylaws, they say we are not a union. And secondly, they can get more members in their legal defense plan, they're happy. I have actually had this conversation with the president of their legal defense plan. He's a former president of a police union down in California, and he's a smart guy. And I said, you know what you're doing here? He said, yeah, it's good for the FOP legal defense plan. Yeah.
And I'm sorry I missed part of that, but I know this with regard to the PORAC plan, the way that they addressed the whole potential Janus fallout was they changed the trust documents. The only way that you're even eligible for participation in the plan is to belong to a sponsor member organization. And if that membership is through WACOPS, if that's through your local guild, whatever that is, you don't get access to it unless you belong, because they didn't want the boards, the local boards, executive boards, to be in a position where they might be violating their DFR relative to the non-members who might want to participate. So at least at this point, that's how they're getting around that Janus problem.
Yeah, and PORAC's going to stay there. I'm
Yeah.
convinced PORAC's going to stay there. I mean, PORAC's a member of our own organization. So, anyway. Okay, last thing. You all need to get out there and tell your members why they should be members, right? You need to tell them this early and often. This is a far too wordy a description of some of the basic principles that you might want to cover. But this is one that one of our clients came up with. I mean, it's good. It's just, you know, in this day and age, we tend not to read paragraph number 2 in anything that we're saying. So what this does is say, look, here's a benefit. This is what union members get, and this is what union members, non-union members get. With respect to representation, you know, unless the law changes and you have to pay the blood, it's the same. Union members get the same as non-members. Representation in disciplinary interviews, this is a union that went to paid play. And you can see that where the union will provide shop stewards and other assistance, it may adopt a paid play plan for non-members. Grievance arbitration, paid play plan for non-members as well. Legal defense coverage, this is groups that have 4X, and yes, union members get it. No, non-members don't get it. Can you vote in union elections? Yes, not if you're a non-member. Can you run for union office? Yes, not if you're a non-member. Can you come to union meetings? Not if you're a non-member. Can you go to the union picnic? Can your kids participate in the union scholarship fund? No, not if you're not a non-member. Many police unions are now going to an app, a cell phone app. It's the way to communicate with their members. Keep in mind that a growing and substantial number of your members, their cell phones are their only computers, right? And for them, even something as recent as email is passé. If you're interested in a union app, by the way, get in touch with them. Business LRS sells them for the grand price of, I think, $69 a month for your whole organization. I'm a total believer that you guys, everyone in this room needs to have apps where you can push out information about what the union is doing, where you can give contact information for your executive board, where you can advise someone, this is what you do in a shoot, et cetera, et cetera, et cetera. Okay, so you can limit the use of the union app. Use of the union's facilities, not for non-members, discounted goods and services, et cetera, et cetera, et cetera. And lastly, and I promise this is lastly, the Kochs and others, and I keep blaming the Kochs, but really, they put tens of millions of dollars into Janus. I mean, they're the ones who are the biggest supporters of this out there. They aren't done, okay? You see web pages out there. This is from an organization that's called My Pay, My Say, saying, union membership is your choice, with a picture of the Statue of Liberty for some reason. You have these groups that are the most active. The Mackinac Center, which is out of Michigan, a little bit out of Wisconsin. It's funded by the Bradley Foundation, another conservative family group, and the Koch Foundation. You have the American Legislative Exchange Council, ALEC, which has had more influence on statewide collective bargaining laws than any group in our lifetime. Another Koch brother funded institution. The Franklin Center for Government and Public Integrity, these are all far right-wing organizations that are focused on unions. And what they are doing is they're going out, they're trying to encourage union members to drop their union membership. It's not just that they wanted to establish the principle of Janus, they don't want unions. It's as simple as that. And so they're urging employees to drop unions. Here you can see what the Washington-based Freedom Foundation is doing. Theoretically, that they have hired 80 canvassers to knock on the doors of public sector workers in California, Oregon, and Washington. They get the addresses through Public Records Act requests, and then correlating it with voter registration lists so they find out where people live. They go to their homes, and their goal for 2018 is reducing union membership by 127,000 in those 3 states. They plan to send their canvassers to governmental buildings as well. You also have the Americans for Prosperity Foundation, which was founded by one of the Koch brothers, and they're going to focus their outreach, and you can see an unusual collection of states there that they're going to focus their outreach on. They're 501c3 organization, so no one gets to know their donors. This is a New York Times article saying that in the wake of the Janus decision, this is only a month after Janus, the campaign is already launched to get union members to drop their membership. You see ads like this, Americans for Fair Treatment, and if you were to sign up for updates here, it would take you to a website that says, here's how you can drop membership in your union, and gives you a withdrawal card from your union. Here's a lawsuit that's being threatened in Oregon by this Illinois group that was behind Janus, actually. And this is a lawsuit that's also it's now been filed in California. And what this lawsuit does is attempt to claw back all union dues paid post-ABOO, so since 1977. And the argument is, since Janus says that ABOO was wrongly decided, that means fair share has never been legal. And if it's never been legal, posing employees with the choice between full membership and something that's illegal was no choice at all. Therefore, all union dues should be refunded to employees who ever had to make that choice. I don't think that has much chance of success, but unions are spending hundreds of thousands of dollars in attorney's fees fighting it. So we're just in a different world right now. The message I want to leave you with is, police are a very unified group. You're not as unified as firefighters, right? You don't have the fire hall and the lazy boys to sit around and talk to each other and all of that sort of stuff. But you're still, as fractious as you can be sometimes, you're still much more unified than teachers or corrections officers or general employee groups. You need to stress to your members what you are doing on their behalf. And you don't just do it now. You do it every occasion you have to talk to your members. You get them involved in your union. You get those younger employees involved in the union who are going to be the future of your organization. Because with that, this actually could be something that strengthens all of us. So that's it for me. Thanks for letting me talk for a couple of hours.